Hmm.
All right, good afternoon, council.
Afternoon.
I think I have everybody logged in.
Good
All right,
afternoon, Judge.
everybody can see and hear me okay?
Yes, Your Honor.
All right, I'm gonna go ahead and call this case. This is cause number 19253. This is in the interest of B.L.A, a child, and we are here today on the department's request for a de novo review of Judge Loftmiller's order on the department's motion to strike jury request. Is that correct?
It is, Your Honor.
Okay. All right, let's go ahead and ask for appearances from council, just because I have a lot of you.
Your Honor, Tonda Curry and Shannon Parker on behalf of the department.
Zach Elliott on behalf of Mr. Alexander.
Darla McElroy, I'm the attorney for respondent mother, Danielle Alexander.
Right. Court has taken time to review the filings and pleadings in this cause number. I have also taken some time to record down the important dates from the filing of the petition all the way through the order denying the motion to strike the jury trial request. So I think I'm pretty much familiar with the chronological history of the case. The only thing that I believe I may be lacking that I think is required under the statute is the written findings and conclusions that Judge Loftmiller made with regards to the department's first motion. I can't find that in the motion. I can't find that in any filing. I think that's necessary for me to conduct a de novo review based on my review of some case law on Family Code 201.015, specifically the Honore E.M. case. Says that party must timely file a written notice of appeal containing the associate judge's findings and conclusions to which the party objects. I find that there is a written notice of appeal in the de novo, but I don't find anything regarding Judge Loftmiller's findings and conclusions. Is that on file anywhere?
Your Honor, we do not believe, to the best of our knowledge, that he has made any to this point.
Have any been requested of him?
Not specifically, Your Honor.
Okay. Mr. Elliott, do you want to chime in here?
Judge, I have not seen any. And for the record, I didn't request it. This will be the 5th and 6th hearing on this issue. And I don't disagree with his ruling.
And what is his ruling? That's what I don't know. I see the order signed, but I don't know what his ruling is. I know it's denied, but.
There have been 4
court.
motion to strike jury demands, and all 4, well, I take that back, 2 in this case, 2 in the next case, all for the same reasons, all denied. And he didn't elaborate beyond that.
So no judicial reasoning given at the bench, nothing oral or written?
No, Your Honor, not that I can recall off the top of my head. I have not seen a transcript, though.
All right, and let me ask the department then, through Ms. Curry, does the filing of the affidavit of indigency on February 24th and Judge Loftmiller's consideration of that and reappointing Mr. Elliott on the 1st, does that, and let me make sure I wrote down my dates correct on that. Am I correct, Mr. Elliott? You were reappointed by Judge Loftmiller on March 1st, about 7 days ago. Is that correct?
To my knowledge, I was never removed. There was a motion. I'm not familiar. It's a new motion that's been filed requesting for attorneys to be dismissed relating to the affidavit. And I immediately got it through the jail system to my client. He immediately returned it, and an order that I remain. So there was never an order that removed me from the case in any
That's
way.
what I'm talking about. But he reappointed you. I mean, there's an order that says you remain, so he's reappointed you. Not that he's ever
Yes.
withdrawn you, but you were appointed, and then he's made some order appointing you again to remain on the case. So there's some kind of judicial consideration that he gave in doing that. Otherwise, he wouldn't have rendered an order. So, but that was on March 1st. Ms. Curry, does that change anything in this case for the department that an affidavit has been filed and that the court has considered it and has ordered Mr. Elliott to remain on the case?
Your Honor, we're still requesting that there be an indigency hearing. The affidavit has been filed. It's our understanding of the law that once the affidavit is filed, that the court, the lower court, is required to conduct an indigency hearing.
And has the associate judge denied the request for an indigency hearing also?
Not in so many words, Your Honor. His view of the law is that it's not required. Or at least that's what he has communicated to us, that he does not believe one is required.
So, but one has not been requested there.
It has, Your Honor, yes.
It has.
Yes.
I'm still at a quandary as to how I'm to conduct a de novo hearing without knowing his conclusions and findings. Unless, Mr. Elliott, you want to waive any objection to that and the court just hear the evidence and we'll just start all the way over. But I mean, there is case law that says that a de novo hearing is not, that a party's not entitled to a de novo hearing unless both of those things are met. A written notice that does contain the judge's findings and conclusions to which the party objects. I can piecemeal it together and say, obviously, whatever the argument is, he didn't buy it and he ordered it denied, and we can go from there if that's sufficient for you, Mr. Elliott.
Judge, respectfully, I did not request the hearing. I've already had this hearing 4 times. If the court would like to proceed, I am ready. I think there are 3 specific statutes where I don't believe there's much wiggle room on this. I think it is what it is. But I will proceed however you wish, Your Honor.
Okay. All right. You may proceed, Ms. Curry.
And Your Honor, like I said earlier, on the issue of the jury demand, it does change the fact that there is now an affidavit on file, an affidavit of indigency on file, and that the jury fee has been paid. It is still our position, however, that the proper prerequisites have not been met for Mr. Elliott to be appointed here. Now, the other thing I realize is that issue is not properly, or at least I don't believe would be properly before the court today, and because no notice was given of that, because we are still waiting on a ruling from Judge Loftmiller on that particular issue to determine whether or not we need to appeal to this court. I believe that this issue for today is solely on the request for a jury demand, and I do believe that the payment of the jury fee, the filing of the affidavit, changes that if Mr. Elliott is properly in the case. I believe we kind of have the cart before the horse here in determining whether or not Mr. Elliott is properly in the case. This case has been on file now for a year and 5 months. We were a year and 4 months in before an affidavit was ever filed, an affidavit of indigency allowing for the appointment of counsel was ever filed, but we still are lacking that indigency hearing to allow the state and the department to test the accuracy of that affidavit and offer any evidence that we may have. But with regard to the issue of jury demand, I agree with the court that for today's hearing, that issue is not fully right.
And so, in other words, you believe that the associate judge in the Child Protection Court will need to conduct an indigency hearing with regards to Mr. Alexander. And then once the court makes a determination in that case, then it would ripen before this court.
Yes, Your Honor.
Okay. All right. So I guess my question then becomes when or will that be requested of the Child Protection Court and Judge Loftmiller?
Your Honor, we have filed a new motion already in the Child Protection Court objecting to the appointment of the attorney without an indigency hearing, and we have filed a separate motion requesting an indigency hearing. Those were filed last week, Judge.
When would you anticipate that would be on the docket for consideration?
There is a docket this Thursday, Judge. It's more likely it would be on March the 25th, however.
March the 25th?
Yes, Judge.
That would push me up against my 30-day deadline. As I understand the law, I've got 30 days to conduct a de novo hearing on your request. And I believe that was filed on February 11th. So that would be outside of the 30 days. And I'm assuming that if there's no objection to that by the department, then we could go forward outside of 30 days. I don't think I lose jurisdiction or anything of that matter, but I believe that, this court could be compelled to conduct a hearing within the 30 days. But if you're requesting to reset this hearing until such time that there's a clarification from the Child Protection Court, and if that held till the 25th, then we could reset to that date and see if this issue becomes ripe.
Yes, and that would be our preference, Judge, and we do not object to going outside the 30 days for that purpose.
Is this going to be the same issue in the next case that's on the court's docket, on the Baker Warner case?
Yes.
You believe
Yes, Your Honor, identical.
Mr. Elliott, I'm sorry, have you filed an affidavit in that case as well now?
I believe, forgive me, I believe I have.
That's what we're checking as well.
Yes, ma'am.
Yes, there has been an affidavit filed. So yes, Judge, the issues would be identical.
Okay. So is it the party's request, or at least the department's request, then to reset this for a time after which the Child Protection Court can take up the issue of indigency? And if the court rules on that without a hearing before the 25th, then I believe that would make it right before this court. However, I would like an opportunity to get some kind of conclusions of findings of fact, conclusions of law that could assist me in conducting my de novo review from Judge Loftmiller. And if he doesn't provide it, he doesn't provide it. But a request that would be appreciated, and I think that would speed along our analysis.
Yes, Judge, and that's just what I was going to say. In the interim, while this issue, the indigency issue is proceeding, we will clarify to Judge Loftmiller our desire for findings of fact on the jury and conclusions of law on the jury demand issue.
All right, let's do this. You're pretty confident that Judge Loftmiller may take that up on the 25th?
Ms. Parker is, Your Honor, yes.
Okay. Give me just a moment. Let me check with Ms. Barker. Let me see if I can find some time. How long do you think we would need? Let's just assume that we need to come back and hear this and hear both of these cases. Although they're separate cases, could we hear them at the same time?
Judge, in my view, these cases, both of them would be primarily legal arguments. The only evidence I think might be evidence of incarceration status. Other than that, I don't think there would be any live testimony at all, and that it would just be legal arguments, and the arguments would be the same, with the slight factual differences of the incarceration.
If we conducted the hearing separately, how much time do you think we would need for each? I think we allotted 30 minutes today for each. Do you think that'd be sufficient?
I think that'd be sufficient. Yes, Your Honor, definitely.
You agree, Mr. Elliott?
Yes, Your Honor.
Okay. All right. Give me just a moment. Let me check the calendar and I'll be right back with you.
Zach,
Yes, ma'am.
hey, he can't hear us now. I don't think. Judge? Okay. Hey, this is nothing against you. We just
I
got,
know that.
okay. We just got to have him doing the right thing on appointing lawyers. He was appointing lawyers to people who weren't even asking for them. So we're just trying to get him to understand the process.
Yes, ma'am. And I'm just doing this for self-preservation. I understand that there's not going to be a child moved to the jail. I just don't want an angry client with a lot of free time in a research library and me to be the easy direction.
Yeah, I get it. I get it. Hey, do you have enough contact with your guys to know if they'll settle? If we make them some kind of
I
offer?
just was able to get in contact with Mr. Alexander, and I mean, he just, seems to really want to see his son based on our conversations. If there's something that's some type of contact or something less than termination, it's just, communicating with somebody who has nothing to lose. And you know what I mean? It can
Yeah,
make it difficult.
I get it. What's the status of mom in that case?
I
Missing in
believe that
action.
she's MIA. Yes, ma'am.
Missing in action.
So
All right,
mom.
counsel.
Oh, sorry, Judge.
Everyone hear me okay?
Yes.
Yeah.
Were we on the record, Judge?
Let's see, I have no audio. Seems like everyone's having a good time but me. Let's see. Let me try it now. I'm not going to tell you what I just did. So, all right. This is the date that we could come back if a hearing is needed. March 31st at 4 p.m. On this case, 19253. And then on the Baker Warner case, 19296, we would do that at 4:30. We'll just keep them separate. I see that we may have different attorneys involved, so we'll just schedule those respectively, 4 and 4:30.
That works for the department, Judge.
Any
Yes, Your
conflicts, Mr.
Honor.
Elliott?
I have no conflicts, no, sir.
And that doesn't conflict with the CPC court, does it?
No.
No, Your Honor.
Okay. All right. Then if a hearing is needed, then we'll resume on those dates at that time, and we will utilize the same Zoom numbers. And obviously, you're all aware of the courts, the Texas Supreme Court's 36th emergency order.
Hmm.
If we need to appear in person, obviously that's going to be available. This court's going to continue conducting Zoom hearings upon request. So matters like these may be easier to conduct via Zoom. However, if there's a need for someone to appear in the courtroom and someone to appear on Zoom, we can conduct all Zoom, all in person, or we could do a hybrid. So just want to let you be aware of that. Okay.
Okay.
Okay, all right, then, if there's nothing further, then, we'll be adjourned and, we'll reconvene on those dates if needed.
Thank you, Judge.
Are we going to convene on the next case now, Judge?
Ma'am?
Are we going to convene on the next case now?
Yes, I can. Well, I'm waiting to see if, I've got Mr. Dunn's on that case. I don't see anyone else other than, Mr. Dunn.
Okay.
And Mr. Dunn would be representing Warner, I believe, no, I'm sorry, I'm sorry.
We have an unknown.
R.J. Baker, Chitty.
Oh, okay.
So I'm not sure that we would need to convene. I can just call that case now if you want to do that, and we can let Mr. Dunn know.
That's fine, Your Honor. I was actually, while you were talking with your your coordinator, we were discussing potential settlement options. I wanted to get back to that conversation.
Okay, well, if you want, I can throw you all in a breakout room and let y'all stay there for a little bit.
That'd be great.
Okay, and I'll tell you what, if, let me go ahead and put this on the record then, in cause number 19296, in the interest of CB and WW children, the court is going to reset that matter for hearing on March 31st at 4:30 p.m. if requested and needed by the parties. And so I will go ahead and I'll put, Ms. McElroy, do you want to be in that breakout room as well, or is it just Mr.?
Yes. Yeah, that'd be fine.
I'm going to send all of you, I'm going to set up the room and I'll send all of you an invitation. And then I'll just let this run and then you can just leave and whenever you're done and I'll monitor it when you're not here.
Okay.
When you're not here, I'll close it out. Or if
All
you
right.
give me a chat message that you're done, either way.
Thank you,
Okay.
Judge.
Thank you, Judge.
All right.
Thank
You're
you,
welcome.
Judge.
You're welcome. So give me just a moment. I'll set them up for you. Do we need more than one room or is one room enough?
One's fine.
Okay.
That's fine.